Good morning, everyone. It's a very early start to be doing a slightly deeper dive into issues of evidence, but I will try to keep this as light as possible. So what we thought would be helpful for you was to have a little bit of a exploration of some of the issues that have faced the courts in dealing with evidence in intellectual property cases, particularly trademarks and copyrights, and why some of these are really quite difficult to resolve and have led to differences in decision between courts at different instances. So the topics, if the first slide can come up. One moment. There we are. Are focusing on the various areas where there are so-called multifactorial evaluations that need to be undertaken by the courts, and why dealing with those is actually quite a challenge. And what I hope to do this morning is to illustrate those issues with some of the cases that also illustrate some of the problems with which the English courts are grappling and with which courts all around the world will increasingly need to grapple. And so the first set of issues I'd just like to discuss is the question of use of a trademark within the jurisdiction. Now, why does that matter? The reason it is important is because under the laws of most countries, I'm sure it's the case here, it is only an infringement of registered trademark if there is use by the defendant in the jurisdiction. Now, when it comes to the marks on physical goods, of course, there is no difficulty. But one of the most common ways, of course, in which goods and indeed services are bought and sold in the modern world is not by physical shops located within the jurisdiction, but online. And so the question arises, how should the courts evaluate a situation where there is online use of a trademark, potentially by companies which are doing business in some way, either actively or passively, in many countries of the world? And we had to look at this case, actually very recently, in a case that I was involved in that case as counsel, which concerned clothing marks. What had happened was a trademark, the Beverly Hills Polo Club trademark, had become divided between two warring brothers in a family. And one of the two brothers had the rights in, broadly speaking, North America, and the other brother had rights, broadly speaking, in the United Kingdom, Europe, and various other non-North American territories. And the brother who had the UK, for these purposes, territory, objected to the fact that on Amazon, because Amazon is a global business, it was possible to see that the products marked Beverly Hills Polo Club were available in the United States on the Amazon website for much lower prices. So let's call him the UK brother, complained about this because he said, you are undermining my attempts to establish the brand as a premium brand rather than as a relatively inexpensive brand. And the goods were in various ways visible on the Amazon web pages that were available in the United Kingdom. And so the question was, does this give rise to infringement of trademark in the United Kingdom? And the courts on this were divided. You will perhaps know that even though in some senses both of the kinds of goods, both the US Beverly Hills Polo Club and the UK and other countries' Polo Club marks, were not in any sense counterfeit. They were both genuine goods of the relevant proprietors. Under UK trademark law and that of many other countries, if one undertaking has rights in one part of the world and another undertaking has rights in another part of the world, it's an infringement for one of them to trespass on the other one's patch. So this was, in some sense, genuine goods with a divided mark, problem that has been an issue in EU trademark law for a number of years and gave rise to one of the most famous trademark cases in EU law, actually about coffee, Coffee Haag case. So the English courts have developed this doctrine of so-called targeting. If an advertisement of goods bearing the trademark on the website of a foreign trader constitutes use of the trademark in the UK, to decide that question, you have to decide whether the advertisement is targeted at consumers in the UK. And as you can imagine, even saying that gives rise to potential difficulties, because if you imagine most businesses of any significant size have websites. Some of them are businesses that are substantially local businesses, but usually you can access most websites from most parts of the world. So the courts have developed this approach to decide whether there is infringement, and one of the constituent elements of it is that the mere fact that a website is accessible from the UK is not sufficient for the goods to be regarded as targeted at the UK. And the question is whether the average consumers would consider that the advertisement or offer for sale, or whatever the case may be, was targeted at them. Evidence can be brought to show that a trader intends to target a given set of consumers in the UK, potentially a principle that applies not just for the UK, in determining whether or not the advertisement actually has that effect. And one of the difficulties with tests of this kind is that they are multifactorial evaluations involving, as you see on the slide, an evaluation of all the relevant circumstances. And as soon as one gets into these evaluations of all the relevant circumstances, the difficulties arise, because you then have to decide as a judge which of the circumstances should be given greater weight, which are of the most relevance. And the Supreme Court in this case, which ultimately the case went to, confirmed some lower court authority, that it included clear expressions of an intention to solicit custom in the UK, case of a website promoting trademark products, including the UK, in a list or a map of geographic areas to which the trader is willing to dispatch its products. So you can imagine the issues to which this gives rise. So if you've bought goods from international websites, Amazon or other websites, quite often you see a little thing in the corner which will tell you the countries to which potentially a product can be shipped, and it's usually for products or websites of that kind around the world. And so the judges have to then evaluate the appearance and content of the websites, which are of particular significance, including whether you can buy goods or services from it. And in international trade, if you want to get goods from Macy's or Bloomingdale's or one of the shops in New York, you can go onto their website or you can phone them up. And they will probably say, yeah, we can certainly ship them to you in Dar es Salaam or in London. And potentially this approach gives rise to a very wide, what might be called international jurisdiction with respect to trademarks. That is made more difficult by the fact that the Supreme Court said that the circumstances may extend beyond the website itself. So you don't just look at the pages of the website and include the nature and size of the trader's business, characteristics of the goods or services, and the number of visits made to the website by consumers in the UK. Now, what happened in that case was that the trial judge held, yeah, you could get some of the goods from Amazon, or the global site of Amazon, but it was a very tiny number of goods that were actually sold to consumers. There was no particular intention to attract custom from the United Kingdom, and he rejected the claim. The Court of Appeal and the Supreme Court disagreed with that, doing a rather different but meticulous analysis of different parts of the customer journey through the website. And you can see with a test of that kind that one is in an area where reasonable courts can differ as to what the outcome should be. It's also, and it's an area that we're going to come on to this afternoon in discussing an aspect of procedure, an evidence-rich area where disclosure, which is provided for in our English rules, is potentially relevant, because under some of these issues you have questions which are themselves addressed by the internal documents of a defendant, which are then potentially relevant to the issues. So that's the first example I want to give you of the difficulties that are currently facing the UK court in looking at trademarks and issues that you may face. Let me then turn to the next example with a segue to the next point, which is an issue that runs through all of trademark and quite a lot of copyright evaluation, and one which, as a judge and appeal tribunal in the trademarks registry, I have found one of the hardest to actually resolve in cases. And it's what I call the diverse consumer issue. In this area of law, so much depends on the perception of a consumer and the notional average consumer who one is trying to identify for the purpose of setting the legal standard. Now, the average consumer in at least UK law, in the context of trademark infringement, is not a real person. It is not any given man or woman in the street. The court tries to identify what might be called a curve or spectrum of consumers, and unless a consumer is notionally in an outlier, so on one end of the spectrum, someone who is just not paying any proper attention to the brand. There was a famous English case which described such a person as a moron in a hurry, who was really not looking at the mark at all, who was very easily confused. And at the other end of the spectrum, the diligent intellectual property lawyer who was brand obsessed, who knew in great detail what these issues were, and who was meticulously examining the similarities and differences between two marks. You have to exclude those two extremes. Otherwise, you need to take account of the whole population. And so in the lifestyle equities case, the Amazon case, what was said was it's enough that a significant proportion of relevant consumers, that is to say those who are reasonably well-informed and circumspect, would consider the website to be directed at them. And that test is not just a test of fact. It is almost a normative test, and it's been described in that way in some of the cases. Would you expect a reasonable average consumer to think certain things about the mark, and in that case the advertising, which gives rise to questions. How many, if one's thinking about this as a numerical issue, is enough to be a significant proportion? How does one set the minimum threshold? And how does the court evaluate evidence from members of the public? Now, that question is difficult enough in the United Kingdom, which is, broadly speaking, an English-speaking country. And I say this in this sense, that the dominant language is English. Everyone speaks English to a reasonable standard, or at least the majority do, even though there are linguistic diversities, and in some parts of the country there are other regional languages, Welsh, and in certain parts Scottish, and then obviously in certain communities particular languages which are dominant. One of the issues that European case law has had to deal with, not just in this context of targeting, but also more generally in confusion, is the issue of diverse linguistic populations. So one of the cases that was on the sheet, Flor de Caña and Flor, the comparison with the two marks that was considered yesterday, gives rise to some very interesting questions in a diverse linguistic population. I was discussing them with Inez yesterday because her first language is Spanish. And so for a Spanish speaker, Flor de Caña actually means something. It's descriptive of a flower of sugarcane. There's a difficulty as to whether sugarcane really has flowers, but leave that point aside. In principle, it's a descriptive term. To someone who doesn't speak Spanish, caña, particularly without the accent, doesn't really mean anything at all. It's an invented word. And so if you have a diverse population, you need to think a little bit about, well, what would a mark mean to not just people who understand the language, but also people who don't understand the language and may be thinking that a word which is perfectly understandable in a given language simply has no meaning. It looks like an invented word in the context of a particular linguistic community. So you have a diverse population, and this is an issue with which I have struggled in the UK, partly not only because of actually different languages meaning different things, but also because there are things like slang, phrases which would have a particular meaning to parts of the community, and regional dialects and so forth, where things would be pronounced in a particular way in one part of the country and pronounced in a different way in another part of the country. So in undertaking the test for confusing similarity or similarity of the marks, one of the questions is oral similarity. So if you have a mark that is pronounced a particular way in one part of the country, it may be very similar to a given either prior mark or a potential infringement. If you have other parts of the country, the relevant term may be pronounced in a different way. And I've had to deal with this in two cases, actually, or the same issue in two cases, one of which where there was said to be a difference in pronunciation between northern England and the south, and another quite recent case where the dispute was whether or not a word had a slang meaning and therefore was descriptive to those people who would understand the slang meaning. And just to give you a sense of the depth to which we had to go in that case, there was reference to a dictionary called the Urban Dictionary. I don't know whether any of you know of the Urban Dictionary, but it is an online resource, if you can really describe it like that. I wouldn't recommend that anyone who is faint-hearted goes to that website, because it is a dictionary of all kinds of really rather rude words, among others, which are in use in certain parts of the community. Things that I certainly would have had no idea about and no idea of the meaning of, things with double meanings and so on. But if one is to apply a test of substantial similarity, and one is to apply it in a way that the whole of the relevant population, or at least relevant parts of the population, would understand, one sometimes has to go into these issues of linguistic diversity in quite some detail. And one of the particularly interesting things about coming here is that this is a country with linguistic diversity. I mean, obviously there is an issue relating to having two dominant languages in which, for a number of words, they're likely to have a meaning in one language and not a meaning in another language, and therefore be descriptive in one language and not another language. And the question then that the courts need to grapple with is, how do we protect trademarks for a diverse population, but also how do we ensure that words that are genuinely descriptive in a given language are not monopolized by someone in that language just because they may not be descriptive in another one of the key languages of a particular jurisdiction. So this issue of meaning, diversity of consumers and so on is one that has particular resonance in countries where, unlike the UK, where people are really very bad at languages, countries which have as the absolute starting point that everyone is bilingual, or many people are bilingual with different facilities to speak languages of different kinds. So I've spent a little bit of time on that because it's a very important issue. And I just want to illustrate this briefly with a couple of other situations. Neutrogena, some of you may like Neutrogena body oil. I'm quite a fan of it. Neutrogena had this reputation in various skincare products, oil products, and the defendants in that case started to market shampoo using the name Neutralia. And Neutrogena sued, passing off trademark infringement, and in that case there wasn't really a difference between trademark infringement and passing off. The case was accepted to be the same for both kinds of cause of action. And so the courts there, the UK courts said, and again this is an issue important for decision making in this area, in a case involving consumer products or services, the court can form its own view as to whether there's a likelihood of misrepresentation without the need for there to be actual witnesses of confusion. The court has to consider whether there's a substantial number of people who were or would be deceived by the defendant's use of the mark, even if there are many or most who would not be deceived. It's not necessary to show that the majority of the relevant population would be confused. And in a case where the judge can't really form a view, evidence of the actual market of what's going on is very important, and I'll come on to that because that's very important in case management of these sorts of issues. So one of the things that's very clear in the English law is that it's not appropriate as a defendant to say, well, 90% of the population, for example, is not confused. If 10% is really confused, that can quite often be a very significant actual number of people. And quite often, the number of people can be people who are, in some cases, vulnerable. And so the court wants to protect them. And so the Court of Appeal said there that there's passing off, even if most people are not fooled most of the time, but enough are for enough of the time. And enough is obviously a matter for evaluation. And in that case, the plaintiffs, I've called them plaintiffs because we changed the name of plaintiffs to claimants. This is a somewhat older case, managed to adduce convincing evidence that there was deception and it was above a trivial level, even though most people were not deceived. And the evidence was very clear that most people weren't deceived. That was a case where disclosure was important because the defendants had to give up all of their internal documents relating to the marketing development. And it turned out that there were documents that showed that second E in Neutralia was regarded as very important by the defendants. They really wanted to keep it. I wonder why, the court said, because they thought actually, obviously, it's the trying to mirror Neutrogena when they could have just had the NU. So it's these sorts of little details in internal marketing documents that really can matter. So let me just conclude on this aspect by an example, a relatively recent example from a case that I had to decide as a deputy concerning sausages. And this gives you an indication of some of the issues in evaluating evidence of this kind. Those are the two marks. The top is the claimant's mark, and the bottom is the defendant's mark. This was a case between Philip Warren, which was an old established family butchers in a small town in Cornwall, which is a very pretty part of the United Kingdom, and which I recommend that you visit should any of you come to the UK. And it is renowned for being a foodie place. When I say foodie, I mean they're very into organic produce, there are great restaurants there, and so on. And this was part of that kind of foodie community. Warren and Sons was a mark that was adopted, actually completely accidentally and coincidentally, by a company you will hear quite a lot about this morning, Lidl. Lidl is one of the biggest food retailers in the UK and in Europe generally. And there is a move in some countries by food retailers to make their products seem a little bit more attractive, a bit more authentic, a bit more kind of back to nature-y or back to kind of idyll of consumers, to adopt marks for their products that kind of have a resonance in this case, a country butchers. And so they adopted that mark for their range of sausages. And they sold millions of sausages under the mark Warren and Sons. They're primarily an own brand retailer, and this was one of their own brands. Anyway, the foodie butchers were very cross because they said, well, this is undermining our reputation for exclusivity and so on. And the question then, for me, was there a misrepresentation? Now, this is actually a very interesting case. It's one of those cases which, in a way, I would set as a textbook case if I was teaching this subject, partly because it sort of has everything in the issues on analysis of these kinds of questions, including the issue of how, in a case of this kind, you assess reputation, and in particular, how you protect local reputation. Because this was a case in which, on the one hand, the claimant had a reputation in the Launceston area. Launceston is a very small town in Cornwall. But they also had some customers around the country from people who would be holiday makers in that region, who would then, when they came back to London or Manchester or wherever it was, would order sausages and beef products to be sent around the country. And they also had a following in a number of the high-end restaurants in London. So there was a question of how you evaluate that as a issue. And the overall bottom line was that the quality of evidence was too poor to conclude that there was a misrepresentation, even though there were some people who had written in and kind of complained about the similarity of the marks. And when I say kind of complained, one of the real difficulties with this area, which I think Inej will look at a little bit more, is that with the proliferation of social media and various forms of ability to comment on aspects of life, in some ways, there is much more evidence available as to what the public think than there used to be, but quite a lot of the evidence is not very reliable. So you've got these little tweets or X's or whatever, or you've got comments that are very brief comments. And in that case, there were a number of the witnesses who came along. It turned out that things that appeared to be evidence of confusion, if you looked at them, just looking at the particular phrase in the context of a given email or whatever it was, looked very damaging. But then when you actually looked at the context in which they were written, it turned out that the relevant author of those comments knew perfectly well that there was a difference between the two companies, was not confused at all, and were simply noting the fact that these marks had an element of similarity, namely the Warren element. So that claim was ultimately unsuccessful, but it was one that I did have some not quite sleepless nights, but was concerned about how one evaluated the evidence. So if you are interested in it, and I'm afraid it is quite long and boring, it gives a picture into the way in which these sorts of things are analyzed, including things like not just the presence of evidence, but the absence of evidence, the absence of an ability to cross-examine actual witnesses on their actual thinking about a market. And that was a case where there was very limited ability to cross-examine actual customers. The claimant hadn't brought along any person who was confused in the local area, even though there was a Lidl just down the road from the butcher's where you could buy these products, and the managing director of the claimant had said, we've had people asking about this in our shop. And from experience, both sitting as a judge and also as a barrister, quite often it turns out that someone who says, this is a very, I was shocked and horrified, turns out that they weren't shocked and horrified by what is the relevant issue for the purposes of the case, but by something completely different, which is exposed in cross-examination. So the importance of being able to test evidence of confusion is a very big one in the UK, and that then depends on the procedures that are there and the availability of things like cross-examination and disclosure. You will tell from this case that it was heard in the middle of the pandemic, and so it was heard remotely. And that actually gives rise to even some particular issues, because you're trying to evaluate the reliability of evidence from members of the public. I was sitting at my desk in a little country house in Hampshire with a not very large computer screen, and you had these witnesses from around the country giving evidence on a sort of tiny portion of the screen, evaluating honesty, looking at the nuances that you get from the way in which people express themselves and so on. That is not that easy an issue to deal with, and we've moved away now, obviously, from doing online hearings other than for procedural matters. So all of these things, the whole richness of evaluation of cases, you can see in some of these cases about consumer reaction. And so there is a slide there about, which I've really gone through, about the nature of the evidence. And one thing that I held was that if there was a very clear inherent likelihood of confusion, the court can make its own view, reach its own view, and treat the evidence as confirmatory of that. But in a case of this kind, there are some cases where, as one of our great judges, Sir Robin Jacobs, said, I simply don't know, and you need actual evidence of confusion. So those are three areas, and in the last few minutes, I just want to mention a few other issues. One is on presumptions. I was asked to talk about those. So in the UK law, there is a presumption that registration is prima facie evidence of validity. So a defendant then has the burden of showing that the mark is invalid. But this is subject to one very important qualification, and that relates to proof of use. So if a mark has been registered in the case of the UK for more than 5 years, then it is subject to what are called the proof of use requirements. And I see that you've got a similar issue in the law here. And then the burden shifts, and it becomes for the proprietor to show what use has been made of the mark. And the deal with the public in the UK law is essentially to say, yeah, you can get your registration, and you can keep it for a certain while, you can put your foot in the door, but after a while, and the burden is on you to show that you have justified the continued extent of the registration and the extent of the registration for all of the goods within the class. And there are many cases where someone might have got a very wide specification, only used in relation to a certain more limited number of marks. That is very significant, and there are many cases in the courts about the failure to prove use, and the United Kingdom Intellectual Property Office complains at every opportunity when the hearing officers come along and give speeches in public as to how bad people are at actually crossing the T's and dotting the I's with the evidence from someone who is knowledgeable on that. So that's a big set of issues. And I think just in the interest of time, I'll skip over the full issues on proof of use in the UK and EU, but the standards that are set there, which is more than merely token use, and in particular that minimal use can qualify as genuine use if it's deemed to be justified, but not every proven commercial use will justify the continued use of a mark. Just even saying that, you'll all appreciate that this gives rise to real problems, because on the one hand, you're saying minimal use is enough to maintain a registration. On the other hand, saying, yes, but there are some uses that don't count to maintain the registration. And there have been cases in the European courts and indeed in the UK where people have sold even hundreds of actual physical articles which has not been shown to be sufficient to constitute genuine use of a trademark. So again, this is an instance of the legislature and the courts setting a standard that is in practice quite hard for tribunals to apply. And I think probably the issue is similar here from looking at your laws. So I was going to mention a little bit, and we might do procedure this afternoon on customs seizure, because that's another set of remedies. I'll skip over that for now and just come on finally to a set of issues, picking up on one of the points that was discussed yesterday on copyright and originality, just to give you a flavor of how some of these issues work in this context. One of the points that was raised and where we had a little discussion with His Honour Judge Tuyo from Kenya was this question of a proof of originality. And I just thought I would draw your attention to this because, again, this has arisen quite recently in a case Lidl and Tesco. This was a case which is going to be discussed a little bit more this morning, and a case where Lidl there was the claimant suing Tesco in relation to both copyright infringement and passing off. And as we know from the discussion that we had yesterday, the way in which copyright law has developed in the UK is from the original sort of sweat of the brow approach to the now European approach requiring a level of intellectual creation, and the law there requires that the author is able to express their creative abilities, the production of the work by making free and creative choices, criteria not satisfied where the content is dictated by technical considerations. And the European test is not the same as the earlier skill and labour test applied by the English courts. So the application of that test is actually not always that easy. Artistic merit doesn't matter. The burden of proof lies on the claimant, That's actually rather similar to the case in the Kenya High Court, where it was held the burden was on the claim the burden hadn't been discharged. And there is a relationship with the law of infringement. And this gives rise to the final set of issues which have created some problems and jurisprudence in the UK, and which you may need to grapple with as well, which is the relationship between the subsistence of a right and the scope of protection that the right gives. It's a very big issue in the law of patents, where in the scope of claims, you can sometimes have patents which are justified only on the basis that the scope of protection is very narrow, because if their scope is extended much more broadly, then they come into contact with prior art or various other objections. There's the same principle applies in the context of copyright. So in the Little and Tesco case, the court said whether there's sufficient creativity involved in creation for the work to be original, but the degree of creativity is low, the consequence is that the scope of protection conferred by the copyright in that work is correspondingly narrow, so that only a close copy will infringe. So here you see a very clear connection between the originality requirement and the scope of protection of a work, the substantial similarity test. So the difficulties in application arose there. That was the mark in which copyright was claimed, but the mark was itself a development of an earlier set of marks. So essentially, this was called the Stage 3 work, the mark with the text in which the claimant was asserting copyright. Square version of the logo was created in the form of a blue square with a yellow circular logo and stylized text imposed on it. And what the court held was that the first instance court held there was both originality and infringement. The Court of Appeal said no. What the position was that although the degree of creativity involved in the creation of the Stage 3 work, so it was essentially adding the blue square in a particular shade of blue and with particular dimensions, may have been low, it wasn't a purely mechanical exercise, nor was the result dictated by technical considerations, which left no room for creative freedom. So, applying the very low threshold of intellectual creation test, you might think this is not the most Michelangelo style artistic creation, but applying the very low test, copyright was held to subsist. But there was a sting in the tail. Because the level of creativity was low, shade of blue was Tesco's shade, that was the defendants, they'd used it in their corporate livery, and also used yellow circles in their signage, and there were differences between the yellow and blue, the different marks. There was no infringement. Now that didn't affect the trademark case, which we'll take a look at in the next session, but it affected the copyright case. And I thought I would draw this to your attention because it is a very interesting and easily graspable indication of the importance of looking at some of these cases in the round, not just looking at one side of the equation on originality and not looking at this infringement test. And that actually was more or less what the High Court of Kenya did in the Seagun case, which unfortunately I wasn't familiar with until it was drawn to my attention yesterday. You have the same sort of thinking going on. Originality needs to be shown according to the InfoPac approach and the approach that was established in the US a while ago under the Berne Convention. But one thing that is very relevant is whether or not the defendant has taken more than the idea of the mark, because as you'll know, you can only protect protect expression and ideas. And the last slide, I thought I would just draw your attention to this. Communication to the public. This is not about evidence. This is about the law. And I think the slide may not be up anymore. but what you get is a sense of how much the courts need to look at in order to decide whether the cases that they're deciding are in line or out of line with things that the European Court of Justice in particular has decided. That list of cases was just the list of cases 2 years ago of the cases that the European Court of Justice has decided to make very fine distinctions on what constitutes communication to the public and what doesn't constitute communication to the public. And the object of that slide was actually not to be readable, because you will have said it, you'll have seen it, I can't read that slide, it's ridiculous. What it gives you is the extent of things that you have to then focus on in order to decide some of these cases and the issues with which we're grappling. So that's where we're coming from, and I hope that this has given you a few pointers, things to think about and ask about, and I will now turn over to a very important topic which I just touched on, which is the increasing role of evidence that's available as a result of developments in digital media. Thank you.
Thank you very much, Deputy Judge Alexander. And now, following the program, I will speak a little bit about digital evidence, particularly in trademark disputes. If I can get my slides, please. Great, thank you. Now, before I delve into this topic, I wanted to take the opportunity to also give you a brief explanation of the World Intellectual Property Organization work with judiciary, so you are aware of what we do. Because at WIPO, we acknowledge that judges play an ever-growing role in assuring the balance and efficacy in the IP ecosystem. And the WIPO Judicial Institute, which where I belong to, in collaboration with other relevant WIPO areas, we aim at empowering judiciaries to fulfill this vital role. Now, specifically, we focus on 4 main areas of work, or pillars, as we call them. The first one is to foster increased transnational dialogue for the judicial community. And here we have a flagship annual event that we do since 2018. Some of you know it, and I hope some of you have participated as well, which is the IP Judges Forum that we held every year. And this is an activity where we bring over 300 judges from all over the world. Well, they connect either online or in person in Geneva, and they exchange views and information on common issues that they are dealing related to IP disputes. The second pillar of work is we aim to make available publications and other resources to promote in-depth understanding of topics that are of relevance to the IP judiciary. And this includes, for example, work on commentaries to judgments, as well as bench book. We are currently developing a bench book for the African region, and the United Republic of Tanzania is part of this project. The third area, we also provide a holistic suite of tailored capacity building support to national and regional judiciaries. And this seminar today is part of the program that we have been developing over the past 5 years to support the judiciary of the United Republic of Tanzania. And finally, we also facilitate the use of the WIPOLEX database, which has been mentioned here a few times. And we consider it as a global knowledge of IP-related treaties, of national and regional laws, as well as judicial decisions and judicial systems. And I am happy that the United Republic of Tanzania is part of this database already. Now, going into the topic that I want to discuss today, is about digital or electronic evidence. Now here, there are two definitions which are quite broad. One is from the United Nations Office of Drug and Crime. This is, of course, not necessarily related to IP, but they define the digital evidence as any probative information stored or transmitted in digital form. Now, when I was looking into the laws in the United Republic of Tanzania, I saw you have an Electronic Transactions Act from 2015, which included or amended the Law of Evidence Act to include references on electronic evidence, as you call it in your law. And I quote, it is described as means any data or information stored in electronic form or electronic media or retrieved from a computer system which can be presented as evidence. Now, if we think concretely, what does this mean, and particularly for trademark cases, these are just a few examples of things that can be considered as electronic evidence. And as Deputy Judge Alexander was mentioning earlier, there's been quite a big number of cases that have been relying on this type of evidence, particularly in, for example, social media posts or web pages or search results from search engines, for example, from Google, online comments or reviews. And then there's also, of course, emails and mobile phone files such as WhatsApp messages, but I will not be showing you any cases on those. I will be focusing mostly on social media posts, web page, search results. In some of the cases I will explain. So I will be showing you to inform you a bit of how some courts have been dealing with this type of evidence in the context particularly of proving acquired distinctiveness of a mark, proving as well genuine use of a mark, and lastly, in the context of likelihood of confusion or infringement. And this, in this last area, is particularly on social media, and here there will be two cases. One has already been mentioned, which is the Little versus Tesco, which was heavily relied on digital evidence or comments on Twitter, now X. And another case that I will briefly also mention. Oops. Now, the first case is about acquired distinctiveness. This is a case from the General Court of the European Union. So as you may know, the European Union is this economic political union where they have also established a registration for trademarks that will be valid in the 27 member states. So these are called EU trademarks. And they have established as well regional regulations for determining the registration of this type of trademarks. Now they have in Article 7 the absolute grounds of refusal, which is quite similar to the Trade and Service Marks Act from the United Republic of Tanzania, Section 16, which also establishes the requirement of a sign in order to be registered. It has to have distinctiveness. Now, this can be either inherent distinctiveness or it can be a distinctiveness that is proven through use. Now, the Court of Justice of the European Union, which is a court for the union that also interprets the EU regulations, they have established in a few landmark cases that the burden of proof is on the trademark owner, and that in order to prove the distinctiveness, it requires that at least a significant proportion of the relevant public identifies the goods or services concerned as originating from a particular undertaking because of that mark. Now, based on those main premises, the question that I will delve into is whether the pattern that you see here on the screen is distinctive. Now, this is a design that is used by a very famous and a luxury brand called Louis Vuitton, and they use this type of pattern in their leather bag, in the leather goods and bags, etc. And they obtained an international registration before WIPO to register this pattern as a trademark. Now, this mark was also recognized by the European Union IP Office. However, a few years later, there was an application for a declaration of invalidity, and the question arose to the European IP Office and reached all the way to the General Court, whether this pattern was distinctive and therefore deserved registration. Now, the reason why I mentioned this case is because the evidence that was submitted included not only sales invoices in order to prove that consumers had access to these type of products, also excerpts from catalogs, advertising campaigns and media coverage, statements concerning distribution of magazines, expert statements, opinion polls, but also digital evidence, which is kind of the use of the mark on the internet, which is another way to look at it as well. Now, one thing I wanted to mention as well is because this was an European Union mark, it required that in the 27 member states, the relevant public will consider this pattern that you just saw as distinctive. Now, the problematic part was that there were some member states where Louis Vuitton does not have a physical store, and therefore it was difficult to prove that the consumers there actually saw this pattern as originating from Louis Vuitton. So the evidence basically focused on these particular member states, which were Estonia, Lithuania, Slovenia, and others. Now, going back to the evidence, the digital evidence that was submitted was included printouts from Slovakian websites in Slovak, and this will be important afterwards, so keep it in mind. It contained images of goods bearing the contested mark. There were also statistics that were submitted relating to the part of the population using the internet in a particular time, search results from Google, but particularly google.it, which I don't know if you know about domain names, but there are these national level domain names that basically IT is targeted to Italy. So users in Italy, if they go into Google, they will have google.it. In Tanzania, the top level domain name is TZ. So that's web pages normally that have TZ are targeted and accessed if you are in Tanzania, most likely. You can also access from elsewhere, but they are mostly targeted to that jurisdiction. So here, the search results of images with this pattern were from google.it. You see here, Damir Azur is the name of that pattern, so they were using that name in the Google searches. There were also other reports of the use of the keywords Damir Azur on social media. Now, the General Court, when assessing this evidence, and here it goes back as well to what Deputy Judge Alexander was mentioning before, they established a criteria to see how do we go about with this type of evidence. And here they established two requirements. One is what was already mentioned, which is accessibility to the relevant public. So they also agreed that it is important that the trademark owner demonstrate that these websites target or are consulted by a significant part of the relevant public. Now, they said, what does this mean? So account should be taken to top-level domains. So as we saw, the evidence that was submitted was .it. So this means that it was targeted to Italy, most likely. Also, the language is important. So if the websites are in Italian, as it was the case, it is unlikely that someone in Slovenia will be accessing this type of websites. And then, of course, content. However, the court said, well, that's not exactly enough. So the fact that these websites exist and are, in these languages and have top-level domains that are relevant is not enough. There has to be as well evidence that provides intensity of use from the consumers. Now, this goes a bit beyond what Deputy Judge Alexander mentioned in the cases, because it's not only about proving that actually these users conceive it as targeted to them, but actually it establishes a higher threshold, and it says, well, the trademark owner has to prove that these consumers have interacted with these websites. So this can take the form of traffic analysis reports during the relevant period, that, for example, the consumers have consulted or interacted with the content of the website. So this could take the form of data on the number of visits on the website, or comments. So, for example, there are reviews that you can do on Amazon or shops, online shops, or other web user interaction. So in this case, they established these two criteria to go about this type of evidence. Now, particularly on the evidence that was submitted, the court considered it was not enough. They said, in general terms, there was no information on the intensity of use, so this interaction that I mentioned before. As I mentioned, it was google.it, so the top-level domain and the language, because it was also in Italian, was not relevant. And some of the data that was provided was at a worldwide level, so it doesn't really show that the people that were consulting these websites were from the relevant member states. Now, the second case is also from the General Court, and is in the context of proving genuine use. This you have as well, as was mentioned before, a similar provision on the Trade and Service Marks Act in Tanzania. And this case that I will mention was in the context of an opposition, in opposition of a registration of a mark. So this was a trademark owner from an EU word mark, which was Tequila Revolucion. And this was a word mark that was registered for alcoholic beverages, as you can imagine, tequila. And they were opposing the registration of another EU word mark that was seeking registration, which was Revolution Vodka. Now, one of the requirements was to prove genuine use, that the owner of Tequila Revolucion had to prove that it has been genuinely using his mark over, I think it's 5 years as well in the European Union. And some of the evidence that was submitted by the opponent included as well Google searches to demonstrate that the reputation of that mark at a global level. It included as well statistics relating to advertisements via websites, also advertisements on social media, in Facebook, Twitter, YouTube, videos that were produced by renowned artists, posters on social media as well, and promotional events that were broadcasted on these social networks. Now, according to the opponent, so the owner of Tequila Revolucion, all these social media accounts were accessible to the EU consumers. However, the General Court considered that this evidence related to websites and social media was not decisive and did not sufficiently demonstrate that they were targeting the territory of the European Union, particularly because these websites were in English. They seem to be targeting more the United States and not the European Union, and there was no evidence that supported the assertion that they were specifically targeting the EU consumers. They also went and said it had not been demonstrated that the EU consumers were following these social media accounts, so they were not really accessing this type of campaigns. And also some of the figures that were presented from traffic analysis went beyond the period that they needed to prove, so it was not conclusive evidence showing that during that period they would be consulting this type of websites. Now, finally, the two cases I will present now are from the High Court of England and Wales as well, and they are more in the context of likelihood of confusion and using social media to prove that the average consumer, as was discussed earlier, is confused by some of the marks that are in the market. Now, this is the case of vodka bottles. So it's about the appearance of these vodka bottles. So one company, which is called AU Vodka, they produce this type of vodka bottles that you see on the screen is the right-hand side. They are metallized bottles in gold. they would designate their flavor depending on the color of the cap. So, for example, a black cap will be a flavor, a blue cap will be another one. And they were complaining about the introduction of a similar shaped bottle from another company, which was NE Vodka. Now, the AU bottles had a label with AU, which is the chemical symbol for gold, and also had the number 79, which is also the atomic number for gold. And NE Vodka had another label which had Ne, which is the chemical symbol for neon, and the atomic number for neon, which is 10. And they both had, this will be important later on, they both had a light that would light up the bottles. Now, AU Vodka brought a claim of passing off, which is, you know it, you have it here as well, the common law tort, based roughly on the premise that a business cannot sell their goods on the pretense that they are the goods of a third party. And AU Vodka also applied for an interim injunction to prevent NE Vodka from promoting, offering for sale, or selling their bottles. Now, this case settled, so there's no final decision. However, there is a decision on the interim injunction, which is quite interesting in terms of digital evidence that was heavily based on social media comments. So this is an example of the evidence that was submitted to show that the average consumer was confused by these vodka bottles. So this was a user from Facebook called Christy, and she has this Facebook page that is called Makeup and Chit Chat with Christy. Now, she posted a few photos of the new NE bottles that you see on the screen, for example, and she added a comment saying, "Light up bottle 2." Now, there were a series of comments that came after that. There was one user who said, "Oh, they look exciting," and there was Michelle G, which is the comment that was used later on by the claimant to say there was actual confusion. And she said, "Second, that is not them. I've seen, it's the gold bottles." Now, Christy replies, "That's the AU Vodka, ain't it?" And then Michelle G says, "I'm no good with names, haha, I only notice the fancy bottles." Now, this is kind of the type of evidence that was submitted, as you can imagine, and they were heavily relying on Michelle G's reaction to say there was actual confusion from the consumers about these vodka bottles. Now, the High Court of Justice of England and Wales, Judge Mellor, he decided the interim injunction, and he said, and as mentioned before, context is critically important for assessing alleged instances of actual confusion. So it's not just looking at the comment in itself, but you have to look at the other comments that were made, because also the claimant was particularly focusing on the comment of Michelle G without looking at all the others, and there was no further evidence on the reasons why this statement was made. And so I quote here, he said, "The comments seem to reflect recognition of the similarity in shape of the bottles, but are unlikely to be instances of actual deception. But it is impossible to draw any firm conclusion without seeing the whole context and/or evidence from the commentators which may be led at trial." So as I mentioned, unfortunately, there was no trial, so we don't know what would have happened then, but it's a good already kind of a suggestion on what to do with this type of evidence. Now, the second and final case here has been already mentioned in the previous session, which is the Lidl versus Tesco case. These are both big supermarket chains in the United Kingdom, and in this case, Lidl sued Tesco in 2020. After Tesco started using this yellow circle that you see on the screen against the blue background to promote a club card prices scheme. This was basically a reduced prices kind of a campaign. Now, in bringing the claim, Lidl relied upon its trademark rights in relation to two versions of the Lidl logo. So you see Lidl had registered trademarks including the wordless mark, which is just a circle and the blue background, and also this same mark but with the text Lidl. Now you see here as well the type of signs that Tesco were using for its campaign. Now, Lidl allege here trademark infringement, passing off, and copyright infringement. I will not go into the decision in itself of all of these claims. I know it was mentioned before already a little bit, particularly on copyright. However, this case was heavily relied on Twitter comments and messages. Now, Twitter, now it's called X, and I find interesting because they called this set of comments as little vox populi, which is like, the voice of the public, which I thought it was quite ingenious. And here there's a few comments that I just pulled as an example. For example, one user said the club card hanging boards are literally the Lidl logo. Another one said, I thought this was a little advert based on the color scheme on the aisle banners. So basically all of these comments were members of the public who sent unprompted messages to Tesco or Lidl following the launch of this scheme, identifying a perceived link between those signs and the Lidl logo. Now, what happened? Of course, Tesco argued against this type of evidence. They asked the question whether these messages actually are representative of the average consumer. So we saw already in the previous session, what does that mean? What type of questions should be asked? How many consumers is the average consumer, etc. And then they also argued that there was no evidence on the context of these messages. So there was no evidence provided on the reasons for making these statements, apart from two commentators which were invited to testify. But all the others were not, did not provide any context on this type of messages. However, the High Court judge, this was a decision that was appealed, and the appeal decision was decided a couple of months ago, and it was upheld. But this is the reasoning of the High Court judge. She said, Vox Populi is representative of spontaneous, unprompted comments from the public, which is important. It also said it contains instances of connection being drawn between the Tesco signs and the Lidl mark with text, which appear to be prompted by a perception of price matching by Tesco to Lidl. It says that it shows that there is an understanding that the special club card prices scheme are the very prices that are being matched to Lidl. So there is a link to Lidl reputation as a discounter supermarket. So this evidence was considered as enough to prove this confusion. Now, finally, in the United States, there are a few decisions that I could find that were more from the Trademark Trial and Appeal Board of the IP Office in the US, and they have also provided a not very elaborated analysis on social media. And they have said that, for example, numbers of likes or followers should be put into context. So here we come back to context as well. However, for them, comments would be a good context, for example. So as we saw, the High Court of England and Wales so far considers that context should go even beyond that, not just comments may be enough. And just to finish, looking at your Electronic Transactions Act, I saw that you do have electronic evidence as admissible. You have provided some criteria in Section 18 on how to weight this type of evidence, including reliability on the manner it was generated, stored, or communicated, in the manner in which its integrity was maintained, the manner in which its originator was identified, and any other factor that may be relevant. And finally, there's also a presumption that the electronic evidence is authentic unless it is refuted, and the burden of proof lies on the refuting party. Now, I just wanted to also mention, because it's something I struggled a little bit. We're talking about digital evidence and electronic evidence. However, as you saw in these cases, they're actually documents. If you see the way it is, the form it is submitted to the court are printouts of web pages or printouts of these these comments. However, it is data or information that it is stored in the digital environment. So that's why it's kind of takes a different form. And just to finish, I wanted to leave some questions for you to consider if you ever encounter, I don't know if you have already, but if you ever encounter this type of evidence in your cases. So when it comes to websites and internet searches, so this is mostly about proving that a mark has been used on the internet or if it has acquired distinctiveness showing how it has been used in the internet. So a question to ask is if the evidence of websites and internet searches is sufficient to prove acquired distinctiveness and or genuine use, or and this means should there be evidence provided that the websites target or are consulted by a significant part of the relevant public, as we saw in the United Kingdom, in the EU. This is a criteria that has been widely accepted. But then another question is, should there be also evidence on the intensity of use? So prove that actually the consumers have interacted with these websites, have actually consulted them. So it goes a bit it's a higher threshold to prove. And then on social media, in the context of likelihood of confusion, are messages, comments representative of the average consumer? So this is a question that was raised as well in the previous session. And are the messages and comments sufficient to prove confusion, or is context important? So for example, will it be necessary to prove the reasons for making the statements or the comments, or to look at other comments? And then finally, the evidentiary weight. So how should electronic evidence be weighted with other type of evidence that can be submitted? So how much importance will you give to this type of comments or websites that are provided? Will they take a higher importance on other evidence or not? And with that, I conclude my presentation. Thank you very much. And if there are any comments or questions, I'm happy to. Thank you.
Thank you very much, Ines, for an insightful and very detailed presentation. It is now time for a coffee break. We'll resume our session at 10:15. Thank you.